Today, we're talking about when money turns malicious, high conflict divorce in wealthy families. And with me today is Josh Rieger. Hey, Josh,
Hi,
how are you doing?
I'm good. I'm good. How are you? Everything's
I'm
great.
good. I'm good. So, when money and conflict collide in divorce, things can turn ugly fast, especially when significant wealth is involved. In high net worth splits, it's not uncommon for one spouse, the moneyed spouse, to cut off access to funds and hide financial information, or for the non-moneyed spouse who has access to burn through money on legal fees and other emotional spending. And so these aren't good financial decisions, and they're power plays that deepen both the conflict and the prolonged pain and expense of the divorce. And so that's what we're going to be talking about today. We're going to explore how money becomes a weapon on both sides of the courtroom. And our guest, Josh, is a seasoned litigator and mediator who has handled some of the most complex and contentious divorces. You can read all about Josh and today's episode in the show notes. But with no further ado, Josh, what do you say we jump in?
Let's do it.
I'm going to ask you a personal question so that my audience gets a little bit of a flavor of your non-attorney side. So tell us something unique about you that people who meet you as a litigator or as an attorney might not expect.
Well, despite what I do, I have 4 kids, a happy marriage, and I played in a touring rock band after college and trying to hold off going to law school for a little while, much to my parents' chagrin. But I did it, and we opened up for some major acts, and it was pretty cool. And then I had to grow up. So here we are.
Great. Okay, so let's dive into this. You and I were talking a little bit offline. So, in any high conflict divorce, there can be some real play on that battlefield with money. But the more money people have, I've noticed that these two different things happen. So, let's first start with the moneyed spouse. And I currently have clients on both sides dealing with this. And so, if you have a moneyed spouse who is the less transparent, more high conflict, it's mine, it's not yours. And they shut their spouse out, cut the credit cards up, take all the money out of the joint accounts. And that non moneyed spouse doesn't and maybe never has had a full sense of maybe they have a business and what their business is doing or all the investments or so here you have a non-moneyed spouse who's been living a wealthy lifestyle, but they're entering divorce. They can't pay their attorney. They don't have money for anything. Can you talk us through how that even happens? And then what one's attorney could do to help them kind of level that playing field a little bit?
Sure. In terms of how it happens, in my experience, it tends to happen more often when the individual, let's call the money spouse, owns their own business or is a controlling partner in a business. It's easier that way to keep money in the business in different accounts and away from their spouse. In other words, if I'm a W-2 employee and I work for, let's call it a major financial firm, I get my W-2, right? It's going into my personal bank account. A major firm is not going to do something that could get them in trouble to hide money from me. Yeah, of course, maybe you could defer some bonuses or stock options or something of that nature, but you're still going to get paid. So the issue really becomes is when somebody owns their own business, is that they're able to divert what should be income back into the business in other bank accounts. Cutting off credit cards is, of course, the easiest, and divorce 101 is what I call it. But same thing with if someone owns their own business, all of a sudden it's not making money, it's worthless. I've seen cases where they actually, if something's in a corporation, they'll open up the same name, but under a partnership and divert funds that way. So that's how it could happen in one instance. In terms of what a lawyer could do, the first part is how do I pay my lawyer? Because nobody's going to take the case unless they could at least get a retainer fee. And if it's a case like this, where it's high net worth, where there's significant amount of assets, let's call it, or businesses to be valued, it's going to cost more money. So In the past, what I've done, if I see a case like this and I know that there's money there that's going to come, and other lawyers may look at this and say you're crazy, but I will take a lower retainer. I take the risk if I have to help these people or this person, and to be able to then go after what they are due, because they are also due like representation, similar representation as their money spouse. That's what the law says. It's not like they're going to be behind the eight ball, even though they may be in the beginning, where they don't have a lawyer or they don't have as an effective lawyer, as a seasoned of a lawyer as their spouse. So in that case, let's say took a reduced retainer, the first thing I would do is bring an emergency order to show cause.
I've got two clients right now who just me convincing them that it's not his, it's ours. So you're as wealthy as he is. You've been together for decades. But then last night I was speaking to someone and she was going to go out and hire the least expensive attorney she could find because she's got no money. And we were having this conversation. So I'm so glad we're chatting now. So somebody can find enough money, put it on a credit card, take a loan to get the initial retainer. Now, of course, their nervous system is completely dysregulated. They're scared to death. They have no money to pay anything else. Can you explain to our audience what an emergency order to show cause?
Order to show cause.
Yes.
First, what you said is great. It's ours. It's not his. So that's something I will tell people, that you have to look at the marriage as a business partnership. Because this one spouse was out there working and earning and doing these things, you were at home raising the kids. You were making plans for the weekend, planning vacations, food shopping, whatever. It's a business. It's a partnership. You are an equal partner. You are not less than just because somebody else has been telling you that you are less than. So that is a great segue. Yeah.
I always tell my clients, I don't think anyone goes, I'll sign up for slavery and I'll just raise kids, keep the house, be the social coordinator. And if we divorce, I'll just walk away penniless. Sure, I'm all in. Like none of you do that.
Right. Yeah. No, it's a hard mental block for some people to get past after years of hearing one thing. But in terms of what I was saying before, is an emergency order to show cause. The first thing you would do is, if there wasn't an action started, you would file a summons, you would serve the other spouse with a complaint. But an emergency order to show cause, I would go in there, you give about 24 hours notice to the other side if they have a lawyer, to the actual lawyer or to the money spouse themselves, usually via email. And we file for what's called ex parte relief, emergency. You're not just filing a motion or a regular order to show cause where the court could stick it on their calendar 2 weeks, a month, 6 weeks from then. You have to show how I have no money to pay my lawyer. I have no money to pay for my children's food, for my own personal expenses. There are many cases where the money spouse, if they're renting, will stop paying rent. They'll stop paying the mortgage. They've cut up the credit cards. It's desperation time. I have one now that all of a sudden their car disappeared. They returned the car lease. So you have to run into court and stress to the judge that is assigned to you, look, we don't have all the information now. Maybe we only have one tax return, but we have the clients fill out the net worth statement, which is a sworn to financial statement talking about how they live their lifestyle, what their expenses were. And if your expenses are $50,000 a month and that you have to meet your expenses and now it's zero, the court will take a look at that, and they may not obligate the money spouse to pay $50,000 a month, but you're not going to walk out of there empty handed on that day, most likely. Then the money spouse will have a chance to put in their papers, and you would have a chance to put in a reply, and the court makes a decision. What it does is it sets the tone for the case to show your spouse, the other lawyer, and the judge that you're not going to be pushed around, that you are there to help your children, help yourself, protect your rights, and you're not going to be bullied anymore. And I think that's why it's very important.
So I have two questions. One is, I have a client who was in exactly that situation, and the court actually in New York City denied the claim, which we were all quite shocked about. So if you have experience with that, right? So now this individual is really between a terrible rock and a hard place. So that's one question. The other question is, if the court approves something, what does that look like? Is that until the case is complete? What's the time frame And I know it may vary. So if you can give us a little bit of a picture of that.
Of course. So just a follow-up question. The court denied any, it's called pendente lipe, interim relief. It was all denied on the emergency aspect or when the motion was totally submitted
On the
and they wrote a
emergency
decision.
aspect, and what's interesting is the moneyed spouse is the woman.
No.
And so I can't help but believe, but that's just my story. It doesn't mean it's
Yeah.
right, but I can't help but believe there's a little bit of discrimination going on there. But everything, all of the facts were like pretty crystal clear. So I don't know if you have experience with that, if you have any thoughts on that, just because the listener may find themselves in the same position.
I actually do. Now, one thing I tell clients is a lot of what happens, especially in the beginning, has to do with the spin of the wheel and where it lands. If depending on the judge's side and because of how experienced I am and our firm is, we know, okay, how are we going to do X, Y, and Z? How long is it going to take to get there? So I have a case that exists now where I have a very similar situation to what you're describing. And I know we don't want to get personal, but it goes with this. Is my client hadn't worked in about 15 to 20 years, and it happened to me, and I told him to go out and get a job. And he did. And after he got the job, the motion wasn't fully submitted yet. The court looked at the fact that he had a job, and I think it was because it was McMahon, and awarded him money. Not as much as he should have gotten, but they denied the interim relief and they gave him that. And I think, again, it's just the way it happens in society. But what I would tell people if that happens to you is to press forward because it's not over. They may deny the interim relief, but once you have all the facts, and you write the papers and you show a judge, hey, these are how things were getting paid for the entirety of the marriage, and you have bank statements and you have tax returns and you have the other spouse's net worth, which you may not have by the time you file an emergency motion, it's hard to deny fact. And if they do deny fact, it's hard to do, but you could always go to the appellate division. But when things are in front of you that are black and white, like bank statements and tax returns, and sworn to financial affidavits, and it's not just conjecture in a courtroom or going in the back and talking to a judge, and it's hard to deny fact.
So the first part was, what if you get denied? And the second part is, if it is approved, what is the time frame that's typically approved?
The term is pendente lipe. It means interim. So generally speaking, it's the length of the case. So let's pretend you make an application, you file an application for maintenance and child support. Maintenance being what everyone commonly refers to as alimony, but it's maintenance. It's retroactive to the date of your application. So let's say you file this, and what date is it? June 4th, and you don't get a decision until September 4th. The court will say the motion or the order to show cause was filed in June, so the money spouse owes the non-money spouse retroactive to June 4th, 2025. And then from there, if the case goes on 2 years, 3 years, 4 years, 5 years, the support continues until ultimately a settlement or the trial decision, unless there's some kind of change in circumstances, such as through no fault of their own, the money spouse loses their job, something happens, and they bring another application to the court. But that it's generally the entire time. Now, sometimes it's too much money that somebody's paying. I've had that happen before, and it really messes things up. Or it's too little, which happens, and it messes things up. But you basically have to figure out how to live with it until the end.
Okay, that's the emergency order. So now in terms of everything else, like the other big piece on this side, before we go over to the other side of the aisle, is a lack of transparency. I have a client, they were in California and they tried mediation, and I'm literally with her 5 years. And he's an expat and he's got all types of stock options and complications and money abroad. 5 years, still hasn't been transparent with his finances, financial people involved, a private judge involved. Still, we don't have the numbers. I'm looking at your face and I'm like, I don't understand. Like, this would never happen in corporate America. And yet, in our US court system, it seems like almost anything can happen.
Okay. Did you say they're still in mediation?
No, they left mediation. They're
Like
in
first,
front of a private judge only because it's hopefully faster than another 5 years in the general court system. But somehow, this individual, moneyed spouse, manages to give 10%, 15% of the information. And the non-moneyed spouse is in so much trouble if she doesn't do everything right. And yet the moneyed spouse for 5 years is like, okay, I'll throw you a bone. I'll throw you a bone. And 5 years later, how do we negotiate when we don't even have the entire picture and it gets complicated?
first of all, I would say that case never should have gone to mediation. They wasted time.
100%.
Yeah. Second, I could only speak to New York, but I know judges here that would never let that stand. Never. There are some where it's a little bit harder to, they got to push more, but you bring, again, it's what we're lawyers, so we can bring motions. We bring what they call discovery motions to produce the documentation. We could subpoena accountants if we know that there where certain bank accounts are. We subpoena the bank accounts. You subpoena not just from the accountant's tax returns, but the information provided to create the tax returns. You depose them. You retain financial forensic accountants to look where money's been moved, whether or not it's moved offshore. It depends where offshore. That's a totally different problem. We've had in the past where I've actually had to retain counsel in another country to help find certain assets. But I would say what ultimately does happen is you may not be able to find everything. However, before when I spoke about the sworn to financial affidavits, the statement of net worth, you get some idea about how people live their lives. And if they lived a certain lifestyle, and one doesn't equal three, or two and two doesn't equal five, right? So you get some idea. And if you have a forensic accountant that could put some of the pieces together and will have to make assumptions on your case, that's really the route that you're looking at. You really may not find out everything. You just might not.
But the key professional, if you're having a hard time accessing a full financial picture, is a forensic accountant.
Correct. Especially if they're a business owner, they have an ownership interest, you cannot operate without one. You would probably be committing malpractice if you were.
So would you say that for our wealthy people, obviously you said it right from the beginning, if you're paid a salary, even a phenomenal salary, it's easy to track. When you're a partner in a partnership or you're part of a family-owned business, that's where it gets a lot more murky. And would you say in those situations between a business valuator and a forensic accountant that you should be able to get a fairly good picture of what's going on?
Well, they're one and the same, really. Most of the forensic accountants that we use, they value the business and they also do an income stream analysis. Look, we had a case once where we went through the books and someone put their new in-ground pool through their books, right? They're like, wait a second, you got an in-ground pool in your office? That's an extreme example. That'll go back to them as income. So they are beyond valuable tools. It costs money. Again, it'll definitely be significant, but they're one and the same. One of the only times where you need two different kinds of evaluators or forensics is if you also own commercial property, because there could be holding companies or management companies that collect rent, that run things through the real estate, and the real estate itself has one value and that company has another value.
My takeaway is, especially if I'm untrusting, I've been in a relationship where money's been hidden from me. When I step in and hire an attorney, I have to trust that if they're saying I need a business valuator, I need a forensic, I need other things, that I am spending good money to really get my best settlement. Because I think that I've heard so often from my clients, and these attorneys, they're taking all this money from me. And I'm like, well, wait a second, there's a difference between spending and investing. And if you don't invest in the right experts, you're going to end up with a much smaller settlement. And so what I'm hearing you say is it is well worth investing in these ancillary experts when you have highly complex finances, even if you currently have very little money to work with?
Well, the first thing is if you have very little money to work with and you need a forensic, you would bring part of your application to the court would be for fees to hire either your own forensic or for the court to appoint a neutral, which in a lot of ways is probably, depending on how complicated it is, the best idea because the court will probably rely on that forensic more than if it was your own forensic. And you could always hire somebody later if you don't like, if the report's not the best, to figure out what's wrong with it. So you can talk to the forensic, because you get drafts. But again, it depends on the type of business, how complicated it is. And I spoke before about you may need certain experts to evaluate stock options and if somebody has money in hedge funds or something. So it would be, again, I really believe this. Like, I'm a lawyer. I have an idea by looking at books and everything about what's going on with the business, but not enough an idea to advise you. So I have what you could do is if you hire a forensic and you could ask them in the beginning to just, this is a term, back of the napkin. What do you think? Should we keep going?
Yep.
And I do that pretty frequently. I'm like, what are we looking at here? How much more money should we put in? Because I am conscious about how much this costs, about how much the lawyers cost.
Right.
And it could blow up very fast. But what I will tell clients is, one, your spouse also control. What are you fighting about? What, you have to do a cost benefit analysis. If it's going to cost you $200,000 to get $1 million, you do it every day. If it's going to cost you $1 million to get $200,000, what are we doing?
So let's go to my final question on this side of the aisle. Then we're going to take a commercial break and go to the other party. So can you share the range of possibility in these types of cases when it comes to having the non-moneyed spouse's legal fees covered? How do we deal with that? Because that's such a big chunk of it. We understand that you're not talking about the entire country. We understand you're giving a broad stroke perspective here. So given that, what's the range that one can expect? I've got clients who are like, how am I going to pay my legal fees, even if I got enough money to feed the kids and put gas in my car? And so I think my question is more, what typically happens? For me, the first thought that comes to mind is, well, if there's a settlement of $3 million, do both parties' legal fees come off the top? What's typically happens when we're dealing with legal fees that are rather substantial?
Okay, so the first part is, when we were talking about that order to show cause before in the beginning, is you would request legal fees in the order to show cause as well. So during the case, like pendente lite interim, during the case, the non-money spouse, the spouse should not, basically rule of thumb is you should not be forced to spend your assets down to litigate the action, especially when you have someone that's a money spouse that makes a significant amount of money and the non-money spouse that doesn't. They'll use the income that's coming in currently to say, hey, you have to pay based on what the attorney is estimating the work is to be done, based on their experience, based on their hourly. You got to keep this afloat because that person is entitled to the same representation that you are, and you cannot basically crush them financially into submission. That's the law.
And that's where the court would come in like a cop and protect the non-moneyed spouse in some way.
Correct. At the end of the case, when it's all over, the court will look at equitable distribution, what the non-money spouse is getting, everything, the whole financial package. And they'll also will look at the quote unquote, I mean, it's New York, dilatory tactics. If one party wouldn't give discovery, if one party made ridiculous demands, their positions were outrageous, they prolonged litigation, all of those things. And it factors in to the award of legal fees, because if someone just basically says, no, the sky's not blue, the sky is red, and they maintain that position for years, it shouldn't be on the person that's acting logical and reasonable to have to pay someone like me for an additional 3 years when it makes no sense.
Beautiful. So, I have one client she's like, my fees are like so much higher than his because I'm fighting every little thing and he's kicking the can down the road and he's not being transparent. And folks, family court system is broken from coast to coast. So these are all how it should be. It's not always this way, but at least we're giving some structure here. Okay, we're going to stop for a sponsor break, and then we're going to come back and talk about the struggles the money spouse has when the non-moneyed spouse is behaving as the more high conflict and financially irresponsible. Divorce feels like an overwhelming perfect storm as you navigate pain, fear, and confusion while struggling with unfamiliar legal procedures and the pressure to make complex decisions that will impact the rest of your life. Our free Rapid Relief Call provides the clarity and confidence you're yearning for. Visit rapidreliefcall.com for support and guidance today. Okay, now we want to talk about the non-moneyed spouse. I work with a lot of men who are very successful, but who are the more codependent, have been abused or shut down in the marriage. And so they're making the money, but it's their spouses and that are outspending. So what do you do when this situation just happened? What do you do when your spouse is calling the attorney every day, running through legal fees, wanting to renovate the vacation home, and really spending money that the rules are you're not supposed to spend except for your normal expenses? How does a moneyed spouse protect themselves from that happening without being out of integrity and shutting their spouse out of everything, which they don't want to do?
Well, there's a couple answers here because when you were talking about spending money on lawyers, renovating a house, let's take that they have, in this scenario, they have a joint bank account, right? They think, so the joint bank account has $1 million in it. What I would tell my client, if this starts happening, take out half of it. It's yours anyway. Just take it. Let her run to court and say, I needed that extra $500,000 for what? For what? What do you need that for? You don't need it. You just want to spend it because you want to build up this lifestyle that you may be living, but maybe not, and you want to show the court that you need it. So I think a lot of that could also be a strategy on the non-money spouse that's spending it. I would also figure out with my client, maybe their accountant or their financial advisor, or based on the net worth statements. And I don't mean to say it in such a way because a marriage is equal, but it's some form of an allowance. What does this person need every week for groceries? What does this person need if the kids are with them primarily at the time, for their car, for gas? Figure out something that is reasonable. And if they were renovating a house, I would just take out all the money and say, go to court and tell them you need to renovate the house. It sounds ruthless, but you got to put a stop to it because you don't really know how things are going to break in a case, and they could be spending, quote unquote, becomes your money as well.
And the children's rights. So you could be really worried that they're spending all the money that should ultimately go to your kids as well, or they're buying a Maserati or something. And so I think that if you can just speak a little bit to that general rule of you have every right to live a similar lifestyle that you have been living, but you're not supposed, there's this whole rule about what you're not supposed to spend on. Can you just talk about that a little bit?
Yeah, you're supposed to be able to continue living the lifestyle that you've been accustomed to, the status quo. What that means is that is usually very different to each party, but there's not a straight and narrow saying, oh, you can't do this, you can't do that. But I would call it more common sense. Like the renovation of the house, that's not common sense. It could be highly likely the house is sold when this is all said and done. Why are you renovating it? Is it add the value to the house? And does somebody get credit for that? So that would be something, I know it's just an example, but egregious. Same thing with going out and buying a Maserati. If the odds are, if you have $100,000 car, you probably have another one, right? You don't need so you've already got one sitting there. Or go lease an Audi or a Mercedes. Yeah, there's just common sense.
Right.
So there's no hard and fast rule. I would say the only, well, I won't actually, we're on the non-money spouse now, so I won't go backwards. But in terms of calling your lawyer, because that I see that a lot, where I have the money spouse and they last month that they spent 10% or of what the non-money spouse spent because they're constantly on the phone. Again, I would say no more. You're not getting any more money. I would look at the bill with my client and say, okay, if we've already paid X amount, maybe we'll give Y this month, but they're done. Let them go to court and let a judge see what's going on. And if the judge rules one way, that's one thing, but we're not just going to write a check for $100,000.
Am I hearing you say if the non-moneyed spouse is out there running up, let's say, a legal bill early on of $50,000, $75,000, the other guy's got the moneyed spouse has a bill of $20,000, and now they're being accused of not enabling the other spouse to continue their legal representation. You bring all of that to the judge. The judge is a fairly rational, legally minded person. They're going to look at that and see that something is off and rule. And what does that look like?
Well, correct. Very often, the non-money spouse's bill is higher than the moneyed spouse, especially in a case where you're trying to figure out, about if the money spouse owns a business and you're trying to gather records and organize everything and go through discovery. And so that's rational. I understand that. And even if they don't own their own business, if they have stock options, if they have money, different accounts, and you got to gather information, your non-money spouse doesn't know as much, so maybe they're not as financially as savvy, so you got to figure it out with them and for them. But if it's just phone calls and the non-money spouse is being billed by 2 or 3 lawyers for the same questions on the phone and the same things, that's something that I would say that you would take a look at. You'd say, hey, judge, look, they have 3 lawyers at X number right now. We're talking about how she doesn't have enough money to go buy the sundress for the Hamptons this year. It's not, they're spending more money than this is worth. And that's something that would certainly be taken into consideration. And the judge may say, if they make a motion for, let's say, $100,000, the judge may say, you're not getting 100,000, maybe you get 40 or something, or 50. But again, these are calculated risks that you have to sit down with your client when they are the money spouse and think about, okay, what's their exposure? You have to look at the other bills. You have to look at your bills. You have to look at the issues. You're not going to say, don't give them that money if it's going to cost, if they're going to get the money anyway, and then it's going to cost them for you to defend it. It's just, it's a cost benefit analysis, but the judge will rule. Yeah.
Okay. And I think my last question is, what's another challenge that the moneyed spouse might have around this topic, other than what I brought up?
Understanding that even though their spouse didn't necessarily work in their business, maybe hasn't worked in 20, 30 years, whatever it is, that they are going to be paying alimony for a decent amount of time, child support with their children that, are not unemancipated, and will have to write, their business will be valued, their stocks will be valued, and they're going to have to pay them. And it's going to hurt. They're also going to have to lay out money for these forensic accountants that I was talking about, neutral or otherwise, and it's going to hurt. And
do you have to have that conversation with the moneyed spouse too, that it's not yours, it's ours?
Of course, all the time, every day. And some people understand and some people don't understand. And what I tell them is, look, if you're the moneyed spouse in a case, you want to get out as quickly as possible because that you don't want to spend as much money. It doesn't behoove you to stay in. If you're the non-money and he's got a big order of support and the case lasts long, some ways, who cares? You're okay. But you want to go from point A to point B, or A to Z, let's say. You don't want to stop at B, C, D, E, F. And I would advise them in the beginning, there's going to be a forensic. Let's get ahead of it. Let me talk to the other lawyer. Let's see if we could agree on someone. Let's just pay them. Let's get the ball rolling. Let's get started. Let me talk to your accountant. Give me everything, as transparent as we could be, because there's no real cash businesses anymore. Of course, there's some, but everything is traceable. They're going to find out. Get it over with. Rip the Band-Aid and get out.
Okay.
And because you will save money in the end if you fight it.
Right. And then my last question is, what about the moneyed spouse who's also the codependent, has the lesser of power imbalance, is on the non-moneyed spouse who's, for whatever reason, a big personality? I have had so many moneyed spouses, mostly men, who literally will give away the entire house and not even buy a cup of coffee. Like they so go in the other direction. Have you had experiences like that? And how do you speak to that moneyed spouse who is really going to undercut themselves just because of their own issues?
I've had that happen. I've had it happen when it's, believe it or not, the women are a number of times high-powered women that make a million% of the money, and they have these tremendous jobs, but they are just, when it comes to their spouse, controlled. I will tell them that, again, what they're entitled to. And that the truth is, I won't let them sign certain things. I won't let them do it. You came to me for a reason. We're counselors. My kids may not listen to my advice, but you should. And I've had cases where I've said, I'm not doing this, and they wanted to settle it, and it's not because
no, that is not in your best interest. We're not doing
that is not in your best interest. I don't want my name on this. And usually at that point, they're like, wait a second, I'm paying this guy and he's telling me not to do this.
Yeah.
Maybe I should listen. Or believe it or not, there are times I'll bring in a friend or a parent and I'll sit down, because depending on their age, or a sibling, they'll listen. I'm not trying to tell you not to settle and continue to pay me. What I'm trying to do is to make sure that you yourself don't give away the farm, and then all of a sudden your kids are living in this beautiful home or apartment and you're in a basement. That's an extreme example, and then they come visit you and they're like, what happened here? You have to think about that too.
Beautiful. I know we could go so much deeper and we could probably talk for a couple of hours on this, but we don't have that kind of time. So how can our listeners find you? And please, I know the name of your firm you've got like 5 names, but I know you also have a URL. So how can they find your firm? How can they find you?
It's Berkman, Bacher, Newman and Shine. I'm Josh Rieger. My wife and my mother call me Joshua, so whatever you guys want to call me. I'm personally located primarily in the Garden City office on Long Island, and our website is berkbot.com, BERKBOT.com, and our phone numbers and emails, they're all up there. So if anybody wants to chat, feel free.
Beautiful. And all of that's in the show notes for you. I have been working with Jacqueline, who's one of the principals, Jacqueline Newman, for years. Her staff is incredible. Obviously, you can see how knowledgeable Joshua is. And so if you're in the Long Island, New York City area and you're looking for a good attorney, I highly recommend this firm and Joshua. And thank you so much for coming. To me, that was so helpful, really cleared up a lot of things. And I know that it's going to help a lot of people as they listen to this episode.
Oh, thank you.
So folks, listen again with pen and paper if that's helpful. And I will be back again real soon. You have a great day. Thanks for joining us on the Journey Beyond Divorce podcast. I hope you found guidance and encouragement to help you along your journey. If you like my podcast, please take a minute to subscribe and leave a review on iTunes. You can also visit us at jbddivorcesupport.com, where our team of coaches support both men and women through our one-on-one coaching, group programs, online courses, and free resources. Stay tuned for our next episode, and I'll talk to you soon.